Sorry for being so tardy coming back, but we'd now like to hear from Elizabeth May, the Member of Parliament from my riding of Saanich Gulf Islands. So with that, Ms May, I think you understand the clock system, and we're looking forward to hearing your oral summary argument. Thank you.
I was also aware that you're a resident of Sydney, so I represent you in Parliament. Among the other residents of Saanich Gulf Islands. I also have in common with Ms. Scott. We went to the same law school, and I've yet to figure out what Mr. Davies and I have in common, but we'll find something.
I might challenge you in that later.
Well, I want to start by acknowledging that we're on the traditional territory of the Coast Salish peoples of the Tsleil-Waututh, Musqueam, and Squamish First Nations. I'm also honored to take the podium right after Squamish First Nation and Aaron Bruce, and very compelling final argument. My constituents form a number of the interveners before you in this panel. As it happens, Dr. Andrew Weaver is a constituent, and as is Adam Olson, who spoke as a member of the Sartlet First Nation. Dr. David Farmer, a very distinguished scientist, is also one of my constituents. And there are 4 First Nations within Saanich Gulf Islands, 3 of which presented significant final argument as well as evidence before you. So I have to explain that I'm here in my capacity as a Member of Parliament. I applied for intervener status nearly 2 years ago to represent the interests of my constituents. I'm here in that sense in a nonpartisan way. By way of some background, I first appeared before National Energy Board as counsel in 1981. I am very familiar with National Energy Board in its previous state, which we used to refer to as a quasi-judicial body. I know the nature of administrative law has moved apace, and there's now the notion of a spectrum of different bodies between courts of law through administrative bodies. But it's very clear that much has changed in National Energy Board process, which has made this particular application enormously challenging. Challenging for the interveners, challenging for the public, and as you've heard in many of the final arguments already, the target of promised political changes from our new Prime Minister. The challenge to this process is also doubly difficult because of the changes that were made in the spring of 2012 in Omnibus Budget Bill C-38, which I vigorously opposed. And for the first time, the National Energy Board was put in charge, as were a number of other regulatory energy bodies, of environmental assessment. And with all due respect, I think the National Energy Board is completely unsuited and inexperienced and should never again be put in charge of environmental assessment. But that's obviously not your decision. It was a decision made by a parliament that pushed it through under the previous Prime Minister. But as a result of those changes, there were timelines associated with this hearing, and those timelines were used as the excuse to drive quite a few changes in terms of procedural rights for interveners. This has raised many issues throughout this hearing of procedural fairness, and I think those arguments are serious. Procedural fairness was not observed in denying oral cross-examination, for example. But in this final argument, what I want to try to do is, in a cross-cutting way, look at the issue of the lack of oral cross-examination, not just as a matter of an offense to the rights of people like me as interveners, but to the quality of the evidence you have before you as decision makers. Because the essence of cross-examination is not just an aspect of fairness to participants. It is, for the adjudicators of facts, an essential way that evidence is tested and facts can be determined, and I submit to you that there is a significant frailty to the evidence that would not be in place had cross-examination occurred. So I want to go through some of those issues with you, and I will use it, as I said, in a cross-cutting way. Now, let me explain what I did as an intervener in approaching Trans Mountain's application. I can't really, it must be an age thing or a generational thing, I can't cope with things that are just on internet or that I can access electronically. So I printed it out. I took it to the local print shop. It came to 23,000 pages. And then I sorted it. I actually dealt with it physically. I went through and removed all the duplicative bits, all the repetitive descriptions of the project, all of the PowerPoint presentations that were identical, but for the name of the town where it was presented and the date. I took out all the repetitive, non-important, irrelevant material. That set aside several thousand pages. I went back and then sorted through the very useful description of the area as it now is, our healthy environment as it exists, and of course recognizing, as the Squamish Nation just pointed out, clam beds have been lost. It's not entirely a pristine environment, but there's a good description, and there's a description of the economic benefits of the various sectors that are at risk here. I set that aside, and I read everything else. Now, my conclusion is that Trans Mountain set out to make their application unnecessarily long with the intention of intimidating people from actually approaching it and doing what I did. Very few people will have read every section in the various parts of the application. And when Trans Mountain claims that they've been rigorous or that their 8 volumes somehow connote some level of diligence, I submit to you that it was entirely aimed at discouraging public engagement. It's in reading the document in its entirety that it becomes clear that Trans Mountain applied, for instance, very different approaches to some risks than to others. In the absence of cross-examination, I wasn't able to put this to them, but I would submit to you in final argument that repeatedly Trans Mountain rejects certain scenarios as low probability, low likelihood, and particularly plausible worst-case scenarios, such as those put forward in the excellent analyses from the City of Vancouver, from Burnaby, from groups like Living Oceans, from the Tsleil-Waututh First Nation. They set those aside, and you can find a reference to their dismissal of those in page 331 of their final argument. Similar comment in response to my information requests at page 15 of my second IR, and Trans Mountain responded, an oil spill from a project-related tanker is a low likelihood occurrence. These are repetitive. They say a tank farm fire, again, low likelihood occurrence. On the other hand, some very low probability events, I'd say on the order of vanishingly small to nil, get a lot of attention. Highly fanciful low probability events are described in detail in the Agriculture Assessment Technical Report, Volume A3, S2, K9, pages 7 and to 12, is the discussion of the risk of pipeline construction increasing avian flu. They put forward the hypothetical risk that a construction worker will blunder into a poultry barn and through viral material on their boots contaminate poultry. I can't find any record of this ever happening in real life, unlike a lot of low probability events such as pipeline breaks and tanker leaks that do happen in real life. But they'll put attention to this, and they're going to make sure their construction workers wear booties and have foot baths available to avoid contaminating the poultry barns. Do you think anyone here think there's any chance of a construction worker deciding to blunder into a poultry barn? Okay, another one is the threat to milk production in that same volume, A3S2K9, at page 2 to 7, where they, and I quote, Kinder Morgan has determined, quote, milk cows are very curious, unquote. And they then conclude that there's a risk to milk production because the curious milk cows will become fascinated by the pipeline construction and it might diminish production. I think, well, if there had been cross-examination, I would have liked to put to them, why are these fanciful low probability events treated as credible by you, but a worst-case scenario of an accident in Vancouver is not credible? The role of cross-examination is more than procedural fairness. It is about testing the quality of the evidence. And any book on evidence will tell you that it's particularly essential when issues of credibility are at stake, but it's also generally of assistance in weighing competing expert reports. In a normal NEB hearing, I would have been here with experts able to cross-examine experts and ask questions that went to the heart of whether they knew what they were doing when they did certain studies. Now, the novel approach taken in this hearing, and this is unprecedented to have no access to cross-examination, but it's not just a question of whether interveners got oral cross-examination or written. That isn't the issue. And it hit me the other day when I was preparing this argument. We never got to question the witnesses at all. We were able to ask questions in writing of Kinder Morgan, and I suspect their legal counsel prepared the answers. We never got to ask any questions at all of the witnesses who prepared the evidence on which this application is based. And similarly, none of our expert witnesses who prepared reports, and I speak of our and a collectivity of interveners, were subjected to cross-examination. So it's a really huge level of disconnect here between those who presented the evidence as experts and those who intervened to try to get to the truth of the matter. And what it does is it fundamentally undermines the reliability of the evidence that you must rely on in coming to your decision. It's an enormous flaw in a process, and it's not just about procedural fairness, although it is that. It is more fundamentally about a disconnect between those who prepared the evidence and their proxies who prepared, as you've heard from many interveners, completely unsatisfactory replies. In essence, the interveners were never allowed to put any questions at all to those people in a position to answer the questions. And this leaves the National Energy Board with a pile of untested evidence. Now, I'm going to go in my next section of what I want to put to you some specific examples of where cross-examination would have helped. A key focus that I looked at as an intervener is the behavior of bitumen and diluent in water, both marine and freshwater. Now, at page 333 of their final argument, Trans Mountain makes it clear that it again confirms that it primarily relied on its Gainford study. Now, one thing about scientific evidence is that, in a sense, the scientific peer review process does something that in a legal context cross-examination also does. It verifies. So the Gainford study, it must be noted, was not peer-reviewed. Now, the Gainford study was asked 3 questions, but it was not, for instance, within the scope of that study to ask, can you recover bitumen once it sinks below the water? That was not included. And nor was it included to study what happens, how much of the diluent will volatilize, how much benzene is going to get in the atmosphere. That was not part of the Gainford study. Now, I asked questions about the Gainford study repeatedly, and I never got satisfactory answers. Now, part of the reason was this disconnect of it being in writing, and the other part was I was asking essentially Trans Mountain lawyers and not the people who did the study. But Trans Mountain has focused all of their confidence that bitumen and diluent will behave the way crude will behave in marine environment on a one-time only 10-day study. So when I asked repeatedly if they didn't agree that it would be, if this wasn't not inadequate for large-scale conclusions, the response in the information reply was to point out that 10 days was enough because the cleanup crews will have arrived. The 10 days is enough to know that you're going to get your booms and you're going to start the cleanup effort within 10 days. But that wasn't the main point of my question. I tried again. I mean, this was a very inadequate test with inadequate tools. They had a small pail test where it's reported in the evidence that they didn't have a ruler wide enough. The spill went a little bit wider than the ruler they had. The people who did the study report in their notes that it would have been a good idea to repeat the experiment with better equipment. So when I asked Kinder Morgan, wouldn't it be a good idea, since it's in a comment in the Gainford study, it would be a good idea to do it more than once, since the equipment wasn't all that good. And basically, they took fresh water, they added salt. They're in Gainford, Alberta. They failed to meet the temperature or the pH parameters that were set in the study going in because it was an exceptionally hot time in Alberta. The temperature, they said, well, maybe that's like summer in the Burrard Inlet. I mean, they have obviously not been in the Burrard Inlet in summer. It was a completely non-responsive reply that I got from Kinder Morgan, but they did say, don't worry, other studies have corroborated what we found in the Gainford study. But that's increasingly not the case. Increasingly, and I submitted in my evidence one study done with much more sophisticated equipment at the Bedford Institute of Technology. Bedford Institute study was led by King, lead author et al., titled Flume Tank Studies to Elucidate the Fate and Behavior of Diluted Bitumen Spilled at Sea. Now, this study was peer-reviewed, so that's one hint in terms of what evidence can be more reliable. And it is on the evidentiary record because I submitted it in the evidentiary period. Now, the King study, and this is also significant, found that, quote, all the product would likely sink in freshwater environments, close quote. That's important. The question of how diluent and bitumen will behave at sea is of grave concern to the people of Saanich Gulf Islands. But so, too, is the risk of pipeline spills all along the route. And in freshwater, all the product would likely sink, close quote. Now, what the King study found about seawater, and they had the advantage of using actual ocean water. They had the advantage of tanks that actually did a better job of simulating what an ocean natural weathering would be. They found, quote, after 7 days of natural weathering, some of the, what they refer to as AWB, Access Western Blend, but basically the bitumen material, became dense enough in the form of oil balls to sink in brackish water, close quote, from the King study, which is in my evidence. Now, a similar finding I've included in the evidence. This is a joint 3 federal department study of Environment Canada, as it was then called, the Department of Fisheries and Oceans, and Natural Resources Canada. In my evidence, it's submitted as what they had as a PowerPoint presentation of February 4, 2015. And they also confirmed oil balls form and sink. Now, in reply to my interrogatories and information requests, Trans Mountain said, and this is in my second IR, under letter H as a response, Trans Mountain says, quote, recently announced studies include those led by the Royal Society of Canada and the U.S. National Academy of Sciences. It's at page 7 of 23. Now, this was in Kinder Morgan's effort to say, well, lots more studies are coming. But you'll note they didn't want to hear those studies when they were published. Having referenced the U.S. National Academy of Sciences report in their response to me, I think Trans Mountain should have been stopped from objecting to the introduction of that study in evidence here. It was rejected as unfair to Trans Mountain to accept a new study which doesn't corroborate their Gainford 10-day test. As Dr. Andrew Weaver has pointed out in his written evidence, written final argument, the Royal Society of Canada expert panel and the U.S. National Academy of Sciences report, quote, make it clear that we simply do not know enough to properly assess the risk and potential damages associated with diluted bitumen spill in the Salish Sea. Now, further, and this was just recently that you heard from Dr. David Farmer in person, as you've also heard from Dr. Weaver in person, but Dr. Farmer's evidence is quite compelling that the Trans Mountain model, which is private to them and was never submitted for peer review as a model, but the model was inadequate and utterly fails to consider the oil subduction caused by tidal fronts in the San Juan and Gulf Islands marine route. Now, Dr. Farmer, I have to say, is both a constituent, but when I looked at his CV, he's a modest man. I hope you looked at his CV. To be a fellow of the Royal Society of London and the Royal Society of Canada, I don't think any of the people who submitted any expert evidence for Trans Mountain have that distinguished a scientific career as Dr. Farmer. But what he proved, I would say he has proven, that Trans Mountain misunderstood the physical processes involved, and even of the literature they referenced in their own application. Dr. Farmer's written final argument notes that, quote, Trans Mountain, quote, appears not to have reviewed the literature it references in its application. This was the sort of thing that needed real cross-examination. Now, another place where we needed real cross-examination is the risk of pipeline accidents. While Trans Mountain repeatedly points out throughout its evidence, throughout its argument, that tankers leaving the Westridge terminal are not their responsibility nor under their control, clearly pipelines are directly their business and directly in their control. With over 116 at least salmon-bearing crossings in BC alone, and that's admitted by Trans Mountain at page 305 of their final argument, and particularly the Fraser River and its critical importance for so many different salmon runs. Any pipeline accident, such as the one which actually occurred in Kalamazoo, Michigan, under Enbridge's control, could have devastating impacts. In this cross-examination of Trans Mountain's confidence in its own record, despite the numerous accidents that have been reported in which the City of Vancouver final argument makes very clear are relevant, but its reliance on its detection systems, early warnings, bells, whistles, alarms, technology will make sure that pipelines don't fail. Now that, by the way, is referred to at page 147 of Trans Mountain's final argument, how much they rely on the great technology to warn them that make it almost impossible to imagine a serious pipeline accident. So the reason I submitted in my evidence the report of the U.S., I mean, it's really the U.S. the Transportation Safety Board accident report on the Kalamazoo, Michigan spill. I recommend it to you as individual panel commissioners to read this. To read, it's not just one example of human error. It's a catalog. When this was released, the press release and the comments from the U.S. agencies that reviewed this were that Enbridge had a culture of negligence. And part of a culture of negligence comes from extreme confidence in your technology and a kind of complacency that comes from that. So sure enough, I mean, when the pipeline broke in Michigan, the bells and whistles all worked. There were 20-minute alarms ringing in headquarters, in the control booth. And the technology people there, the engineers, the people running Enbridge's pipeline, looked at the bells and the whistles and heard the alarms. And just like as if we were at home and we had a piece of toast stuck in the toaster and it set off the alarm in the house, they went around switching off the alarms because they concluded, well, there's a pressure drop because we were testing the pipeline, so there's nothing wrong here. Our equipment is malfunctioning. One shift went home. The next shift showed up. The first shift never told the second shift they'd had alarms. 81% of the bitumen and diluent that contaminates the Kalamazoo River to this day, 81% of that spill occurred after the alarms because they chose to ignore them. It's instructive to know what happens in real life. I would have liked to have asked them questions about that on cross-examination. Human error must not be discounted in probability of risks, particularly as Vancouver's evidence and final argument has confirmed. There are numerous other examples of human error. We don't have to go any farther, actually, than imagining how unlikely it was that Vancouver would be dealing with a spill from the Marathaza, a relatively small spill that lapped up on the shores of English Bay. We've had recent experiences with implausible spills. So Vancouver's argument makes it clear, but we know that across all of those salmon-bearing streams, fresh water, if bitumen and diluent leak, it will sink, and it's almost impossible to clean up, as the Kalamazoo, Michigan spill has made it very clear. This should have been cross-examined in evidence. It's not clear that the industry in general, nor Trans Mountain in particular, have learned anything from the Kalamazoo accident. In fact, I was astonished to find this quote at page 286 of Trans Mountain's final argument, in which they say, quote, "Evidence from actual case studies showed that freshwater ecosystems recover from oil spills, often within relatively short periods of time," close quote. Well, they certainly can't be referring to bitumen and diluent, because our experience with that is entirely to the contrary. I mean, you know, the fuel truck that spilled into Goldstream, we remember that. That was horrific. But the damage was limited pretty much to 1 year. The salmon were back the following year. So I don't know what evidence from actual case studies Trans Mountain wants to cite, but we know when bitumen and diluent spill in fresh water, there is not a quick recovery. So our last example of where cross-examination was essential and not allowed is the one issue I know on the record that really deals with credibility. The credibility of an expert report that used information that should never have been cited. Now, this issue was first identified by former intervener Robin Allen, and I think in the public interest and for all Canadians, a public thank you to Robin Allen for diligent work. I understand her reasons for withdrawing from this process. You can see I want to give it the old college try and keep fighting to ask you to turn this project down in your recommendation. But Robin Allen identified the use of an Environmental Protection Agency document from the U.S. government in Dr. H.J. Rutenbeek's study on estimating oil spill costs. Contrary to Trans Mountain's protestations, Rutenbeek did cite a study by Dagmar Etkin. That study was cited in his expert report to this body as, quote, Etkin, DS 2004, Modeling Oil Spill Response and Damage Costs, U.S. EPA. Now, if you seek that out on the U.S. EPA website, it appears as, in capital letters, draft. And it says, do not cite or quote, close quote. But on the copy that was included in the evidence to this panel, that disclaimer was not on the copy provided to the National Energy Board. Now, this is not a small matter. So the fact that a disputed and unethically sourced document is actually the only source cited by Rutenbeek that dealt with terrestrial data. So any conclusions by Rutenbeek on costs of a spill on land had to have included that information. Now, it's on the record, it's in the evidence, it's in many of the motions and applications from Robin Allen, that when she contacted the U.S. EPA, they said, no, that was a draft that was eliminated at the first stage of peer review because it's not a reliable approach. Now, Trans Mountain claims it's all inconsequential, whether it was a draft or a final, but I think it contaminates the basis of the evidence. This is the strongest example because it goes to the issue of credibility, where an expert should have been asked on the stand. Maybe there's a sound answer, but we were never able to ask either Rutenbeek or Atkins how they decided to white out the words draft, do not cite. This is exactly where cross-examination is necessary, or it undermines the integrity of the evidence. And if there is a valid explanation for this, neither Etkin nor Rutenbeek were ever put forward to explain themselves. Additional points. As the Member of Parliament for Saanich Gulf Islands, I have an interesting role in relation to the First Nations communities in my riding. We have a nation-to-nation relationship, and yet I'm also their MP and work for them. They're my constituents. They're my boss. They're also First Nations. And as the Sout and Sartlip briefs so strongly put it, they explain the Douglas Treaties. Now, the Douglas Treaties are among the strongest, clearest treaties to protect in perpetuity rights of First Nations peoples and the Coast Salish peoples to use of and fishing rights and so on. It's very clear. So I do not stand here to speak for First Nations. That would be completely inappropriate. I raise my hands. I'm so grateful to Tsleil-Waututh, to Squamish, to all the First Nations that have come here to protect our home. As we heard from Aaron Bruce, they speak of Squamish Nation as home. It's our home too. I have to say I find it disturbing that Trans Mountain refuses to use the words First Nations in its argumentation or evidence. They refer to First Nations as Aboriginal groups, as if they're mere stakeholders. I think there's a potentially profound misunderstanding of the constitutionally protected rights and treaty rights of First Nations. Now, primarily, it's the fiduciary responsibility of the Crown. I completely agree with the lawyer for Squamish Nation. It's the honor of the Crown that's at stake here. But it needs to be noted that this project cannot be approved without offending our Constitution, inherent rights of First Nations, and treaty rights. Secondly, I wish to provide full support to all the interveners who argued that it was inappropriate for the National Energy Board to exclude climate change as a key, in fact, the most vital consideration. I'm updating slightly Vancouver's excellent final argument in which they spoke of the importance of avoiding 2 degrees Celsius global average temperature increase, but under the recently concluded Paris Agreement of December 2015, it's 1.5 degrees Celsius that we must strive to avoid. That translates into a very different energy future. That translates into moving away from fossil fuels as quickly as possible. As you've heard from numerous witnesses, this goes to many different levels of question. What kind of security and so-called need for the project, what's in the public interest for Canada? To exclude climate change is, I think, an egregious mistake that goes to the heart of this issue. In a similar context, in the United States, when the State Department did an environmental impact statement on Keystone Pipeline, they made greenhouse gas implications the key question, and they studied it, and it was on that basis that they turned down Keystone. So it remains, as a member of Parliament for me, and I think most of my constituents, find it incomprehensible that climate considerations were excluded in this process. The next issue that needs to be mentioned is the threat to the southern resident killer whale populations. I know this troubles the board. It troubled me that when the Department of Fisheries and Oceans made recommendations to Trans Mountain about steps they could take, Trans Mountain's approach is just to say, well, we're one of many out there who threaten the survival of the species. There's nothing specifically in the responsibility of Trans Mountain to take steps to protect the southern resident killer whale population from both the noise of the increased tanker traffic going from one a week to one a day. Is going to have a very significant impact. We're talking about a threat of accident that could really damage the entire marine ecosystem. So there's no specific responsibility felt at this point by Trans Mountain, and I think that's fatal to their application. I also want to support the evidence and the final argument of one of Canada's largest labour organizations, Unifor. Unifor's evidence is that the Trans Mountain expansion threatens existing jobs in Canada's refineries, particularly specifically here in Burnaby at the Chevron refinery. It also threatens other value-added jobs because shipping out raw bitumen is all about not refining it in Canada. And it's a threat to many thousands of people who work in the commercial fisheries. Now, Unifor's final argument notes, quote, the panel determined that consideration of potential adverse impacts of the Trans Mountain expansion on job creation, Canadian energy security, and diversification of the oil and gas sector was beyond its mandate, close quote, page 8, Unifor's final argument. I think that's also lamentable. Even on the economics this project fails, it can only get a green light under public interest if key risks are excluded, like climate change, and key benefits are overstated, like the economics of the project. This project is, as you've heard from many other interveners, only in Kinder Morgan's interest. So I put it to you in conclusion that, as other members of the public who have tried to come here as interveners have tried to say, this process is broken through no fault of your own. Bill C-38 took a hatchet to environmental assessment and mucked up the role of the NEB. On top of that, after 2 years, nearly 2 years since I applied to be an intervener, I find it astonishing that this is my first time to be allowed in the room. With a little tag that says if I leave the room, I have to surrender the tag and have to apply to come back in the room. This level of security doesn't exist at the Supreme Court of Canada, nor in the Parliament of Canada. We're at a public hearing, and as people can see, as this is live streamed, the room is mostly empty because unless you've applied ahead of time, and I could bring one friend with me, I should have introduced her by now. Dr. Lynn Cornby is the chair of the biochemistry department at Simon Fraser University. And when Kinder Morgan boasts of its stakeholder engagement, I suppose that includes filing a lawsuit against Dr. Lynn Cornby for $5 million for what they called tortious conspiracy, because she had the gall to protest their project and to write an op-ed about it. The lawsuit has since been removed. This is a broken process. On the science, Kinder Morgan has to get a failing grade. Real scientists have come before you, like Dr. Andrew Weaver. I recall for you his "you can't make this stuff up" moment. Real scientists have come before you, like Dr. David Farmer, like Dr. Andrew Weaver. On the science, Kinder Morgan gets a failing grade. So we must take, and I submit that you must take, careful stock of where governments stand on this project. The government of British Columbia says its conditions have not been met. The municipalities of Vancouver, Burnaby, Victoria, North and West Vancouver, as well as First Nations, have called on you to use your discretion as finders of fact and as makers of a recommendation to say, we recommend this is not in the public interest. We must look at particularly the leading efforts of First Nations and recognize the constitutional implications, as I've already referenced. This project fails to meet the public interest test even when you exclude things that are off the list. It represents an unacceptable risk to ecosystems, endangered species, existing industries, economic activities, and livelihoods. It poses a threat to thousands and thousands of British Columbians, a risk for which there is no benefit to those same British Columbians. It fails a national test in the public interest. So I urge you as commissioners and members of the National Energy Board to review the evidence fairly. Look at the weight of the intervener evidence. Consider the frailty of evidence that has not been tested under cross-examination, and bear in mind that peer-reviewed studies have at least had some real review, whereas Kinder Morgan's evidence, for the most part, has had none. I acknowledge that foundation of any decision is evidence, but you must have a foundation on which you can build something. And the evidence put before you by the applicant isn't solid. It's shifting sands. I urge you, in fact, I beg you, I implore you, to recommend against this project, its application, any license for it. It must die here. Thank you.